Hi everyone, I hope you're all doing well this week. As promised, the LICM is back with a short video on residential leases and everything you need to know about tenant rights in Quebec. My name is Alexa. I'm the Director of Communications at the LICM, and I'll be introducing you to some key rights that you should know if you ever plan on renting an apartment in Montreal. If you missed our first video where William, our Executive Director, explains what the LICM is and tells you all about the many free services that we offer students, don't forget to check it out after this. So now I'm just going to share these slides and begin the presentation. So actually, just before I get into the substance of the presentation, I want to take a moment to acknowledge the ancestral lands that the LICM is located on. The LICM is located on the traditional territory of the Kanien'kehá:ka and Anishinaabe nations, a place which has long served as a site of meeting and exchange amongst nations. We recognize and respect the Kanien'kehá:ka and Anishinaabe nations as the traditional custodians of the lands and waters on which we meet today. Before I begin the presentations, I also have to let you know that in accordance with Article 128 of the Act respecting the Barreau du Québec, only lawyers and notaries can give legal advice in Quebec. Law students can only provide information. So nothing in the following presentation should be construed as or relied upon as legal advice. All right, so let's get started with residential leases in Quebec. So today I'll be covering the following topics. What is the Régie du Logement? Are deposits legal? Who can cancel a lease and when? What is negotiating, transferring, and subleasing? And finally, which co-tenant is responsible for paying the rent? The Régie du Logement is a special administrative tribunal that was created specifically for residential disputes and is responsible for hearing all disputes between tenants and landlord in Quebec. Tenants and landlord can open a file at the Régie for any of the reasons listed on the slide. For example, if a tenant wants to file a complaint against their landlord because they're refusing to do repair in their apartment, they would go to the Régie. Or if a landlord and a tenant disagree about how much the rent should be, one of the parties could also go to the Régie to get the rent fixed. Usually you'd be able to visit the Régie in person to apply for a hearing if you have a dispute with your landlord, but right now, due to COVID-19, the Régie's offices are operating primarily remotely, with most of the hearings taking place over video conference. However, they do maintain a telephone information service as well as their full range of services online, meaning you can still file an application for a hearing right now, but you have to do it on their website. So here we have a little scenario. So Julia's from Toronto. She's a first-year student at McGill. She lives in residence, but next year she wants to move in with her friends. In January, with her two friends, Melissa and Camille, she agrees to sign a one-year lease that starts in September for the perfect apartment. However, when she's signing the lease, the landlord asks Julia for a security deposit. Julia is uncomfortable with this and she's not sure what she should do. Are deposits legal? No. The law is very clear in Quebec. A landlord cannot ask a tenant for more than 1 month's rent at a time. The only payment that the landlord can ask for in advance is the first month's rent. The landlord cannot ask for any form of deposit when a tenant is signing the lease, whether it be for security, furniture, anything else like that. I know in some other Canadian provinces, it's common to ask for first and last. It's not allowed in Quebec to ask for the last month's rent. The landlord can really only ask for the first when you sign the lease. Can Julia cancel her lease? So Julia went ahead and signed her lease. She didn't give a deposit besides first month's rent. But then in March, the university closed due to COVID-19, and Julia went back home to Toronto to live with her parents for the remainder of the semester. Eventually, McGill announced that classes would be held remotely in the fall, and in light of this announcement, Julia decided that she wants to stay home with her parents for the fall semester. Can she cancel her lease, which starts in September? So let's go over a few ways that a tenant can end a lease in Quebec. You may have heard that a tenant may break a lease at any point, either by giving 3 months notice or by paying 3 months rent. This is not true. Normally, the lease ends at the end of the fixed term, which in Quebec is usually 12 months for a standard lease, if the tenant gives the landlord a notice of non-renewal at least 3 months before the end of the lease. In Quebec, Residential leases are automatically renewed on the same terms unless the landlord has taken steps to change the terms, for example, by increasing the rent, or the tenant notifies the landlord that they're not renewing their lease. If the tenant wants to leave, they have to send their landlord that notice of non-renewal at least 3 months before the end of the lease. And the notice is actually available on the Régie du Logement's website. However, the landlord and the tenant can, if they both agree, end the lease at any time before the end that was fixed when the lease was signed. Otherwise, if they can't agree, there are only very few circumstances in which the tenant can end the lease on their own. So first, if the dwelling is no longer habitable and this was not caused by the tenant. In that case, the tenant must notify the landlord before leaving or at least within 10 days of their departure. Second, if the tenant must move into a hospital, medical center, or low-income housing, they can end the lease by themselves, but they must give their landlord a notice of 1 to 2 months before leaving. And finally, if the spouse of the tenant becomes dangerous and it's no longer safe for the tenant to live in the dwelling, they can also end the lease by themselves. And again, they must give their landlord 1 to 2 months notice before leaving. There's also a few situations in which the landlord can end the lease by themselves. So first, if a tenant has not paid their rent for 3 weeks or is often late in paying their rent. Second, if the tenant hinders the peaceable enjoyment of their neighbors in the building. So for example, if they're being aggressive or they're harassing other tenants. Third, if the landlord wants to repossess the dwelling for themselves or for an immediate family member, for example, their son or daughter or a parent, at the end of the term of the lease though. And lastly, again, at the end of the lease, if the landlord wants to take back the dwelling to make major renovations. These are the only situations in which a landlord may lawfully end the lease. In addition, the landlord must give the tenant 6 months notice of an eviction, or they must apply to the Régie before ending the lease. So you might be wondering if the COVID-19 pandemic is a legitimate reason for Julia to end her lease. Well, it's complicated. Many have been wondering if the pandemic counts as a force majeure, superior force in English, in Quebec. In other words, an event that's beyond your control and that makes it impossible to fulfill a contract. Whether something counts as a force majeure is decided on a case-by-case basis, but it's generally a pretty high bar and only applies if it's truly impossible for a contract to be fulfilled due to the unforeseeable event. For example, COVID-19 might be considered a force majeure with regards to having to cancel the reservation for a space for a wedding, as it is now prohibited by law to gather in very large numbers, and therefore no longer possible to host the wedding. But it would likely not be considered a force majeure with regards to the sale of a home, as that is still very much possible, pandemic or not. When it comes to a lease, it's still possible for Julia to fulfill her obligation to pay the rent, regardless of whether or not it's actually possible for her to live in the apartment. As long as Julia is able to pay the rent and her landlord is able to provide her with the peaceful enjoyment of the premises, she'll be expected to fulfill her contractual obligation. The important consideration when it comes to an unforeseeable event like COVID-19 is whether the performance of the contract is truly impossible. It's still possible for Julia to pay her rent during COVID, so she cannot end the lease for this reason. Julia now knows that COVID-19 is not a legitimate reason for her to end the lease. However, she still wants to stay in Toronto for the fall semester and would prefer not to pay rent for her apartment in Montreal. What are her options? Well, there are 3 options available to Julia if she doesn't want to pay rent for the apartment in Montreal while she stays in Toronto in the fall. First, she can negotiate with her landlord. Second, she could assign her lease, which is commonly referred to as a lease transfer. Or third, she could sublet her lease. Negotiating with the landlord is a first step that may allow the tenant to avoid more complicated processes. While it's difficult for a tenant, as we saw, to unilaterally end a lease, it is possible to end one lease if both parties, the tenant and the landlord, agree. Thus, depending on the tenant's relationship with the landlord, it might be possible to negotiate an early termination of the lease. It is always preferable to have any agreement of this sort put down in writing, even if only over text message or email. If negotiations is not a possibility or if it falls through, assigning a lease is another option. Assigning a lease or a lease transfer means that the person you assign the lease to takes over all rights and responsibilities of the lease, including paying the rent. If Julia wants to assign her lease, she will need to find someone who wants her lease, and then she must send a notice to her landlord that this person is taking over. Examples of notices that have to be sent to the landlord can be found on the Régie's website. Julia's landlord would then have 15 days to respond to the notice, and they could only deny the assignment if they had a serious reason for doing so. For example, if they're seriously concerned about the new tenant's ability to pay the rent. If they don't respond within 15 days, the assignment is presumed to be accepted. A step-by-step guide can also be found on the McGill Housing website for how to assign a lease if ever that was something you needed to do. Finally, if Julia doesn't find someone to assign her lease to, or if she plans on moving back to Montreal for the winter semester, she can sublet. Subletting is a temporary arrangement, meaning that Julia still stays on the lease and has a right to return to her apartment when the sublease agreement ends, but it also means that she is still responsible for rent in the case that her sublet does not pay. So for example, she could sublease her apartment from September to December if she wanted to move back in January. And exactly the same as with a lease assignment, she would have to send a notice to her landlord, and they would have 15 days to respond to the notice, and they could only deny if there was a serious reason to do so. Since a sublease is a new contract, the tenant can actually offer different terms to the subletter than the ones they have on their own lease contract. For example, they could lower the rent they charge their subletter if they were trying to attract more offers to sublet, for example, but they would have obviously they would have to be the ones to cover the difference. However, they can't give any rights to the subletters that they don't themselves have. For example, if they agreed on their lease that they wouldn't have any pets in the apartment, they can't then tell their subletter that they'll be allowed to have a pet in the apartment. Also very important to note is that a landlord cannot add a clause to a tenant's lease saying that a sublet or a lease assignment is not allowed. It's your right as a tenant to sublet or assign your lease, and even if the landlord puts a clause like that in the contract, it's not valid and it won't be recognized by courts in Quebec. So always keep that in mind. So Julia, unfortunately, in this situation, was not able to find someone to assign her lease to or to sublet to. After discussing the situation with her parents, she's decided to go to Montreal in the fall and move into her apartment. However, both Melissa and Camille have told Julia that they won't be staying in the apartment in the fall and that they don't plan on paying the rent or finding people to assign their lease or sublet to. Julia is worried that the landlord will make her pay for the entire apartment's rent, which she can't afford. Let's talk a bit about co-tenancy in Quebec. So tenants need to read their lease carefully to know whether they might be responsible for their co-tenant's rent or not. If it's not specified in the lease contract, the tenant will by default have what's called joint responsibility for the rent. This means that each tenant is only responsible for paying their share of the rent. However, if the lease specifies that the tenants are solidarily liable for the rent, each tenant will be responsible for the entire rent. Regardless of how the responsibility is shared though, if one of the tenants ends up paying for the entirety of the rent, they can always require that the other tenants pay them back for their share of the rent. So, is Julia responsible for her co-tenant's rent? Well, it depends. Julia has to read her lease carefully to see if her and her co-tenants are jointly or solidarily liable for the rent. And regardless of which it is, if Julia were to pay the entirety of the rent, she would still have the right to ask Melissa and Camille to reimburse her. The image that you see on the screen is actually a screenshot of the standard lease contract in Quebec, the one that is used for most leases. And you can see in the red box that there's a little line reading, the lessee undertake to be solidarily liable for the lease, yes, no. So if Julia had checked yes, then she would be responsible for the entire rent, as well as Melissa and Camille, obviously. And if she had checked no, she would only be responsible for her part of the rent. So that was all for today on residential leases. I hope this presentation was helpful to you. And if you ever wanted more information on this area of the law, the LICM does offer a Just Info presentation specifically on residential leases. Or if you had a specific legal info question about your own leasing situation, don't hesitate to contact our legal information branch and we will be able to help you out. Finally, once COVID-19 restrictions end, if you ever have a hearing at the Régie du Logement, someone from the LICM can actually accompany you to your hearing. So that was all for today. You can catch us next Monday for a short video where our Director of Community Services, Juliana, will tell you all about what you should know about your rights if you ever decide to get a job in Montreal.